Treason is not the reason for the season. Episode 12, Do you mean arbitrary? Or vague? It is often during debates about where to draw the line for these two categories of weapons, debates such as should we ban bump stocks, should we ban high-capacity magazines, should we ban assault rifles, that during these debates we often encounter one of the more idiotic whines of the militia-as-terrorism extremist, the idiotic idea that wherever you draw the line is arbitrary and therefore somehow, magically, such a law is illegal. If you drive along a highway, you might see a speed limit sign that says 65 mph. If you drive 66 miles per hour, you could get pulled over by the police. 65 is fine. 66 gets you in trouble with the law. So arbitrary. But wait, there's more. If you keep driving along that very same highway, you might encounter a sign that says 55 mph. Just a few feet before that sign, it was perfectly legal to drive 65 miles per hour. And this sign arbitrarily dropped the limit to 55. 1 foot before the sign 65 is legal. A foot beyond the sign, 65 could get you in trouble. So, arbitrary. And then you get into town, and you see a sign that say, of all things, 15 mph school zone, which means, on the weekend, you can drive 25 miles per hour, but on a school day, in that very same spot, you have to limit yourself to 15 miles per hour if you want to stay out of legal trouble. In speed limit laws alone, there is arbitrary clauses based on speed, location, and current time. And yet, all of those speed limit laws, arbitrary as some might claim, are entirely legal. A sawed-off shotgun, as defined by the National Firearms Act, is a shotgun with a barrel length under 18 inches. 18 inches is fine. 17 inches gets you a visit by the ATF and FBI. So arbitrary. And yet, completely legal. So, when some militia-as-terrorism extremists start whining about how drawing a line between two categories of weapons is arbitrary, and therefore somehow magically illegal, keep in mind that they absolutely should not be pretending to be a lawyer with their poor understanding of law. Now, there is a legal concept called the vagueness doctrine that says a vague law is unconstitutional. But vague here means not spelled out in explicit terms. So a law that tries to make vagrancy illegal, without defining exactly what is and is not vagrancy, is too vague. Vague laws are unconstitutional because they violate due process. For example, there's no way for an anti-war protester to know if their peaceful protest march is legal or violates a vaguely worded vagrancy law. They encourage arbitrary arrest and conviction. For example, police who don't like anti-war protesters peacefully marching in the street have arrested protesters for violating vaguely worded vagrancy laws, and vague laws can suppress the expression of constitutional rights. For example, once people are arrested for vagrancy for a peaceful and constitutionally protected anti-war protest, other people may steer far clear of marching in a peaceful protest, even if it was intended by the Constitution to be legal. So, this is the vagueness doctrine. And one problem with a vague law is that it can be arbitrarily enforced by police. But that's not the arbitrary that militia-as-terrorism extremists mean when someone suggests something like, say, banning magazines over 10 rounds. If the law were to ban large-capacity magazines and never explicitly defined what was and was not a large-capacity magazine, that law would violate the vagueness doctrine. It could be arbitrarily enforced and would be unconstitutional. But if a law very explicitly defined what a magazine was and banned any magazine over a 10-round capacity, then that law would pass the vagueness doctrine and would not be arbitrary in any legal sense. People would know ahead of time exactly what magazines are and are not illegal. And the law would be explicit enough that police could not use arbitrary interpretations to arrest people because the cop decided 8 rounds was too many. By defining exactly what a magazine is and stating exactly how many rounds are legal, such a law would be constitutional. This is why the National Firearms Act defines a sawed-off shotgun as requiring a barrel length less than 18 inches. If the NFA just defined a sawed-off shotgun as any shotgun with a barrel that is too short, then every police officer could arbitrarily decide what is and is not legal. Now, it is arbitrary that an 18-inch barrel is legal, but a 17-inch barrel is a sawed-off shotgun with greater legal restrictions. But the 18-inch limit was chosen through the democratic process. If militia-as-terrorism extremists say it's arbitrary to define a sawed-off shotgun as any barrel under 18 inches, then literally every law in the United States is arbitrary. Because every law in the United States must explicitly define where to draw the line between what is and is not legal. 65 miles per hour is legal. 66 miles per hour is not. 0.08 blood alcohol level is legal. 0.09 blood alcohol level is not. When fishing for black grouper, the minimum length is 24 inches. 23-inch groupers must be released. Every law in the U.S. must explicitly draw a line between what is and is not legal. This means every law in the U.S. is arbitrary in the eyes of militia-as-terrorism extremists. When the federal assault weapons ban was in place, the law had a very specific, very explicit definition of what was and was not an assault weapon. It was a bit of a complicated definition. But it was explicit. It had an explicit physical list of things that had to be present on a weapon to be considered an assault weapon, and was therefore banned. Extremists whined that the law was arbitrary. They didn't just whine about it. Several challenges were brought before the courts. All of them were rejected by the court. The courts repeatedly held up the law as constitutional. It passed the vagueness doctrine and was not arbitrary. The founders had no problem with legislating extremely arbitrary, highly specific, entirely not vague laws about firearms. The Militia Act of 1792 contains the following excerpt, quoted here for its delicious arbitrariness. That every citizen, so enrolled and notified, shall, within 6 months thereafter, provide himself with a good musket or firelock, a sufficient bayonet and belt, 2 spare flints, and a knapsack, a pouch, with a box therein, to contain not less than 24 cartridges, suited to the bore of his musket or firelock, each cartridge to contain a proper quantity of powder and ball, or with a good rifle, knapsack, shot pouch, and powder horn, 20 balls suited to the bore of his rifle, and a quarter of a pound of powder, and shall appear so armed, accoutred, and provided, when called out to exercise or into service, except, that when called out on company days to exercise only, he may appear without a knapsack. You think the federal assault weapons ban is arbitrary and therefore illegal? Look how arbitrary the founders were with regard to weapons for militia members. Members had to acquire 24 cartridges. If you showed up for militia service with only 20 cartridges, you were in violation. Members had to possess 2 spare flints. If you only had 1 spare flint, or God forbid, no spare flints, you were in violation. Members needed to possess a quarter pound of powder. 4 ounces. If you showed up with 2 ounces, you were in violation. Members had to possess a knapsack. But if they showed up for militia duty on a training-only day, they didn't need to bring it. A bit later, the Militia Act of 1792 states. After 5 years from the passing of this act, all muskets from arming the militia as is herein required, shall be of bores sufficient for balls of the 18th part of a pound. Every member of the militia, starting 5 years later, in 1797, would be required to possess not just any musket, but a musket with a barrel that could handle a ball that weighed an 18th of a pound. In modern-day terminology, their musket had to have a barrel equivalent to an 18-gauge shotgun. Somewhere between a 12-gauge and 20-gauge shotgun commonly available today. The Founding Fathers specified exactly what size barrel was legal, how many shot was legal, how much powder was legal, how many flints was legal, mandate when a knapsack was legal, mandate a pouch with a box inside of it was legal. But you think a law that specifies that a large capacity magazine over 10 rounds is arbitrary and therefore not legal? You think the definition of assault weapon is arbitrary and not legal? You keep saying arbitrary. But I do not think it means what you think it means. So, when you hear some militia-as-terrorism extremist argue that some gun control law is arbitrary and therefore magically illegal, keep in mind whether they mean the law fails the vagueness doctrine, or whether the law sets an explicit limit, and the extremist is simply making clear that they don't like democracy. Treason is not the reason for the Second Amendment. Treason is not the reason for the season.